So another one of the things that you get in the secured party process is something called a legal notice and demand. And let's talk about the elements of a notice and demand. There is no penalty for making reasonable mistakes in good faith. Remember what good faith is? Good faith and clean hands. However, if one intentionally does harm, then they may be sued. Nevertheless, before he can be sued, he must be given a fair opportunity to correct his error. Okay? The notice gives one that fair opportunity. By it, he may have sufficient notice to assert proper due diligence and inquire further so as to discover that which an inquiry pursued in good faith would disclose. Okay? Now that's out of Black's Law Dictionary. So when we do these administrative processes, okay, we go in with good hands and clean faith, clean hands and good faith, and you give them an opportunity to cure. Okay, so part of your process is you conditionally accept, upon proof of claim, validation of debt letter upon proof of claim. Okay, you accept their presentment, validate it, verification, whatever, right? And then there's a notice of default, which is their opportunity to cure, right? And then you're creating a certificate of non-response because they came at you, they said that you owed them, they don't have a claim, well, they came at you crooked, and they did not come at you, okay, with good faith and clean hands, and you gave them an opportunity to undo their mistake. Okay? Properly assert due diligence and inquire further as to discover the inquiry pursued in good faith would disclose. Okay? There is a wide latitude in the style you use to write the notice. You can pretend you are writing to your sweet old grandma or to the devil himself, which is the IRS. From the court's point of view, the style does not matter if the legal points are made. Choice of style is a strategy decision. What effect do you want to have on the offender? Before sending the notice, remember to apply Mark Twain's 7 rules for good writing. Revise, 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 revise. It takes 7 major revisions to do a notice correctly. In other words, you read it, then you change some stuff, and then you read it again, and then you start at the beginning and you read it, and then you find something and you revise and stuff. So 7 times 7. In your notice to your adversary, make the following points. What is he doing or what is he not doing? What are your injuries? Loss of substantive rights. Notice, injury and damages are not synonymous words. Injury is the harm done. Damages are the compensation for the injury. His duty is not to cause you injury. The moral, public, and private laws that require him not to cause you injury is the 10 Commandments, the Bill of Rights, and all these numbers here. Okay, 18 United States Code, 42 United States Code, and your own damn rules. Okay, is he breaching that duty? He is breaching that duty. State the damages, what he owes you for the injury. Cite the moral, public, and private measurements of the damage. Okay? Again, use the United States Code and your own estimate. Demand that he in good faith do his duty, pay you the damages, and to do so within a reasonable number of days. Usually 60 for government, 30 for everybody else. If he does not do as demanded within the allotted time, then by tacit procreation, assumed power of attorney, you will determine for him the facts, his duties, and the damages he owes you. Now, I think that's spelled wrong because it's procuration. You know what? I'm going to look that up. Okay, so he did not spell it wrong. Procuration is the action of taking care of, hence management, Stewardship, agency, the word is applied to the authority or power delegated to the procurator or agent, as well as to the exercise of such authority expressed. So in our document, it says right next to it, assumed power of attorney. So that's what that means. By tacit power of attorney, you will determine for him the facts, his duties, and the damages he owes you. If he does not perform as demanded, you will take lawful action in personam and in rem to defend against them, and persons acting in concert with him who cause or attempt to cause such injuries to secure your substantive rights and to redeem the damages owed to you. The constructive notice should be served upon the adversary in the same manner that one would serve upon summons on a lawsuit. A proof of service should be executed and held for use as necessary in a future lawsuit. Okay? So this is basically your certificates of service and, summons using a third party, all the stuff we're doing. Okay? Knowledge of the facts which would naturally lead an honest and prudent person to make inquiry constitutes notice of everything which such injury pursued in good faith would disclose. Okay? And there's some case law, and that's Black's law. In addition, in another sense, notice means information and advice or a written warning in more or less formal shape intended to apprise a person of some proceeding in which his interests are involved, or informing him of some fact which is his right to know and the duty of the notifying party to communicate. Okay? That's also Black's law. An actual notice has been defined as notice expressly and actually given and brought home to the party directly. Okay? The term actual notice, however, is generally given a wider meaning as embracing two classes, express and implied. The former includes all knowledge of a degree above that which depends upon collateral inference, or which imposes upon the party the further duty of inquiry. The latter imputes knowledge to the party because he is shown to be conscious of having the means of knowledge. In this sense, actual notice is such notice as is positively proved to have been given to the party, directly and personally, or such as he is presumed to have received personally because the evidence within his knowledge was sufficient to put him upon inquiry. Man, that is a really, really hard way of saying certificate of service. And he got it because I know he got it because he's smart enough to know that he got it when he opened the mailbox and there it was, therefore he got it. And he had knowledge that he got it, so he got it. Constructive notice is information or knowledge of a fact imputed by law to a person, although he might not actually have it, because he could have discovered the fact by proper diligence. Remember that word, due diligence? And his situation was such as to cast upon him the duty of inquiring into it. Constructive notice is a presumption of law, making it impossible for one to deny the matter concerning which notice is given, while implied notice is a presumption of fact, relating to what one can learn by reasonable inquiry and arises from actual notice of circumstances and not from constructive notice. Whew. So constructive means making it impossible for one to deny. Okay? So if you send a constructive notice to somebody, they can't deny it. So you might want to put that in your, this is a legal constructive notice and demand or something. You might want to throw that in the name, but you just might as well try it, right? Okay. or, as otherwise defined, implied notice may be said to exist where the fact in question lies open to the knowledge of the party, so that the exercise of reasonable observation and watchfulness would not fail to apprise him of it, although no one has told him of it in so many words. So, by the way, this is presented by Melvin Stamper, a Juris Doctorate, professor at law. And this is what is called legalese right here, man. Okay? This is the way they get people, upset with the law, and I don't understand, and that's why you need a lawyer. And, man, I tell you what, they could make it a lot easier, couldn't they? Peace.